The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we're prepared to hear our first case, and Ms. McAllister, whenever you're ready, we'd be pleased to hear from you.
Your Honors, and may it please the court. For generations, the Supreme Court has recognized that it is parents who have the fundamental constitutional right to make critical decisions regarding the health, safety, and welfare of their children. And as recently as 2020, schools recognized the primacy of parents as decision makers when, during the COVID pandemic, they sent their children home to the parents to make the decisions necessary during that time. But Mrs. Blair discovered educators have now determined that they and the child have the right to make these critical decisions without parental knowledge or consent when the decisions involve a troubled child who says she identifies as something other than her sex. Only hours before, her 14-year-old daughter, Sage, ran away for fear of the unaddressed threats of harm from her classmates, Mrs. Blair learned from Sage that school officials had been treating her as a boy and directed her to use the boys' bathroom, where she was sexually assaulted and threatened. Running away from the unaddressed threats at school led Sage to be abducted and sex trafficked. When Mrs. Blair sought to vindicate her fundamental rights in the district court, she was turned away when the district court devised its own version of the right at issue and concluded that district officials were entitled to qualified immunity because that newly devised right wasn't clearly established. The court also improperly dismissed Sage's Title IX claim when it concluded that secret transitioning, interrogation by law enforcement without her parents present, and concealing from parents the sexual harassment and assaults in the restroom were not sufficient to allege deliberate indifference. Finally, the court improperly dismissed claims against...
The school board was trying to protect the wishes and privacy of the child.
Yes, Your Honor, that is what they said.
Well, I mean, I don't know why we wouldn't credit that. I mean, the child here did not want the parents to be notified, and should the school board just have overrun the child's wishes? I mean, the school board is in a bind here. It's caught between two family members, but I think they're trying to respect the wishes of this particular student, trying to respect her privacy. Are they not?
That is what they state, Your Honor, but looking at it in context, this needs to be addressed in context with everything that the school counselors and staff knew about this particular student. In this particular student, they knew had a history of mental health issues, and she had just been psychiatrically treated in a residential facility weeks before starting school. And all of that information was available to them, and they knew that that was a problem with this child. And they initiated...
But you're trying to assert a substantive due process right to this information, are you not?
Yes, Mrs. Blair...
Okay. All I'm saying is that the Supreme Court has been very leery of creating a lot of substantive due process rights. And this would land up there, that we created some substantive due process right on the part of parents to certain kinds of information. This would be a very hard thing for the Supreme Court to accept.
Well, respectfully, Your Honor, this is not a new expanded version of substantive due process. The allegations of the complaint that Mrs. Blair made, not the way the district court rewrote them, is squarely
But if
within.
you want to consider the context, the school board here is caught in a very difficult situation. And on the one hand, they want to respect the privacy rights of the child. I understand what you say about the rights of parents, but it's hard to know, if you're a school administrator, if they had disclosed the sexual orientation or the gender preference of the child, that might well, against the child's wishes, that might well have given rise to another lawsuit. And so the school board is betwixt in between.
Well, not really, Your Honor, because this is a 14-year-old minor child who has mental health issues, and it is and under Troxel and Parham, so long as the parent is fit, the parent has the fundamental right to make these kinds of decisions. And there's no allegation, is no allegation that Mrs. Blair was any way unfit. And if there was an allegation that she was unfit, if they believe that, they're mandated reporters.
But if the child wished the information disclosed to the parents, why didn't this child himself or herself make the disclosure? Why is it the school board's obligation as opposed to having that the subject of a family discussion?
Well, because in this situation, again, with the child and the condition of the child, and they already have in place in all schools, and particularly this one, that the child can't walk into the nurse's office and say, I want you to give me a Tylenol, but don't tell my mom you're giving me the Tylenol. She has to get permission, the nurse does, from the parent. So there are all kinds of situations in school where whether the children like it or not, the parents are to be told and are to either consent or not, but they're to be told before things occur that affect the child's mental health, safety, etc. The school here told this young girl who already had mental illness and who they know had been sexually harassed on the bus to start using the boys' bathroom. The girl didn't ask for that and would not have done that had not the counselor said, you need to use the boys' bathroom. And she continued to have her use the boys' bathroom for 2 weeks, even though they knew the child had already been sexually assaulted and threatened and harmed by male classmates. And so at some point, the child's wishes need to... Excuse
me, Judge Gregory had a question.
Oh, I'm sorry.
I just wondered, why are you almost cabining your case to this is not an informational case. It starts that way. It's not just about information informing the parent. It's sending a child who with a mental history of problems, who's already been sexually assaulted. I'm reading the pleadings because this is where we are. This was a 12B6. This is not summary judgment. It's not discovery.
Correct.
And she's been sexually assaulted, and you said, go in the boys' bathroom.
Exactly.
Go in there. And then when she makes complaints about sexual assault, you call the police and then browbeated by, well, you know, if you accuse these boys, they can sue you.
Exactly.
This is a 14-year-old girl. Forget about the transgender aspect of it. This is protecting a child.
Exactly, Your
Period.
Honor. I mean, we also brought, of course, a Title IX claim based on what Your Honor said. Because they also did not tell the parent that she had been sexually harassed and threatened on the bus and in the bathrooms. The only way that mom found out about that was when the daughter herself finally said something, because she had gotten no help from the school, and the school had not done anything to help her, and she still had these boys threatening her with all kinds of horrors. And so, and again, the school just let that happen. And again, when she was brought in, the sheriff's deputy comes in, the SRO, and doesn't tell the parents, and starts interrogating this young girl who they know has a mental health issue, who they know has been assaulted, and try to blame it on her. And again, they don't tell the mother about this. They
Didn't
just-
have a problem with calling the police, though.
They didn't have a problem with calling, no.
Right. And
No.
getting the police involved, but not the parent.
Not the parent. And so really what this is, it's not solely the gender identity issue. It's the issue of the parent not being properly notified of issues that are very significant regarding her child. That her child is using the boys' bathroom, and the boys are, no surprise, mistreating her. And
And the girls didn't want her in that bathroom, right?
correct. Early on, the girl said because she had short hair, she was wearing t-shirts and shorts, and so they just thought, I think she's a boy. They were uncomfortable. But once again, the adults, the authority figures, told this young girl, and this young girl, she's 5'1" and 100 pounds soaking wet.
Yeah, there are a lot of things that you're saying about this, but don't they go rather far afield from the basic claim here, which is that the parent is asserting a substantive due process right to be notified of a child's gender orientation, and is asserting a substantive due process right to such notification against the child's wishes. And I don't know where the school district would have been informed that it had any such duty. But it seems to me the question is a narrow one. It doesn't involve general treatment of this or that or the other. It involves whether a heretofore unannounced right, a substantive due process right of parents to be notified against the child's wishes of the child's gender orientation. And that's going to bring up all sorts of litigation, because school districts are not going to be aware of exactly when the duty to notify kicks in, or when they have transgressed a child's wishes to such an extent that the child's attorney and others are going to be involved. And I don't understand why this kind of thing has to be resolved through litigation as opposed to the particular families involved and the school boards involved and all the rest. It was always open to the child to tell the parents.
Right, but again, Your Honor, looking in the context, this child had significant trauma, significant mental health issues. She'd been already sexually harassed by other students, and this is not.
But that's a different issue from what's before us now, because if there was that kind of sexual harassment or whatever, that's a different case. What's being asserted here as a matter of constitutional law is the right of a parent to be notified against the child's wishes of a child's gender orientation. And I don't know where school boards aware of that kind of duty, and I don't know when they are supposed to know that the duty kicks in, and if it applies to notification of gender orientation, does the duty apply to this other subject and this subject and this subject? Is there a substantive due process right to be notified of A, B, C, D, and E, or just this one matter? There's so many questions that come up and make it a very difficult position for a school to be in, which is to inject itself into the middle of something that is a family dynamic.
Well, yes, Your Honor, but they do have, I mean, we have the Parham case from the Supreme Court, which was similar, where the children did bring a lawsuit because the parents had approved them being committed to mental health.
And because you cited Parham earlier, and I think you cited Troxel.
Yes.
Those cases are a little different because there is already a decision that has been communicated to the school, and the school overturns the decision of the parents. Here, there's no decision, or there's no communication to the school or the school district from the parent that says this child cannot do this, or my child cannot be identified in this way. Wouldn't this, because in those cases, it seems to be like a direct interference with the parents' wishes, whereas here, I'm guessing they're gonna say, we didn't get anything that said that we were not supposed to do this from the parent.
Well, I would think that professionals would not need to be told that they should not send a small girl into the boys' bathroom just because she said she might identify as a boy. She didn't ask for that. They told her that. And Troxel, of course, didn't deal with schools. Troxel dealt with a law that disregarded the parents' right to direct the upbringing of their child. That's the same thing we're saying here. Mrs. Blair had the right to do this, and under Parham, they have the right to make decisions for their minor children.
But the bathroom cases are different here, and the use of the nurse's bathroom was an attempt to respect our previous decisions on this. What we have here is a narrow question of whether we're going to create a new substantive due process right on the part of parents to be notified of this and that and the rest. And what we're doing is we are inserting school boards into the middle of a parent's dynamic when the school board was trying to protect, and that's a reasonable decision, to protect the interest, openly expressed interest of the child, that the parent not be notified. And the school board was trying to do its best to respect that child's witness, because the child has if the child could well have been very fearful of what was going to happen in that home if her gender or his preference had been told. And that's I think we're having courts step into something that is presumptively private between parent and child, and also the school board, and something that might be best resolved without the need for litigation and constitutional rights, substantive due process rights that the Supreme Court is not going to go along with.
Your Honor, my time has expired. May I respond to your...
Why don't you reserve some for rebuttal, because I think you have some for rebuttal.
I do have time for rebuttal, yes, Your Honor.
All right, well, we'll be glad to hear from you then, okay?
Thank you, Your Honor.
Thank you. Ms. York?
Good morning, Your Honors, and may it please the Court. Melissa York here on behalf of Appomattox County School Board Superintendent Dr. Annette Bennett and Counselor Dina Olson. The Court has hit the proverbial nail on the head, and that is that these rights were not clearly established, and that's why the individual defendants were entitled to qualified immunity, and the District Court correctly granted their motion to dismiss. We're talking about the alleged right of a parent to be notified that her child elected to be called by a name different than her name at birth and to use gender nonconforming pronouns at school over a 2-week period, after which time the student ran away and obviously suffered very horrific events, but that's not the fault of the school board. The question is whether it was clearly established that these defendants would know that the actions that they were taken clearly violated a constitutional right. This court, just as recently as 6 weeks ago, restated the standard for a clearly established right, and it has to be, cannot be done in isolation from the perceived facts of the case in which the immunity is claimed. It has to be such that an objectively reasonable officer must understand that what he's doing would violate the right. It must be established at such a high level of particularity because otherwise commonplace generalities would allow plaintiffs to game the system and convert the rule of qualified immunity into virtually unqualified liability. And that's what the appellants seek to do here. They rely upon Troxel and Parham and this fundamental right to the upbringing of one's child and a familial privacy, but they don't define that right within the particular context of the case. And the court—
That's just one part of the case. And that's what I don't understand. It's not just information. If this is not a case where it's solely, I'm suing you because you didn't tell me my child identified as transgender. If that was the case, then if that was the sole case, that may be a different case. But it's always the facts that tell you what to do, not wit, but the law. We're talking about a 14-year-old child being told, and they suggest, go into the boys' bathroom. And you don't think common sense has anything to do with that action being absolutely ridiculous?
Well, no, Your Honor.
Answer my question. Do you think that that's reasonable to say, oh, you identified it? Go into the boys' bathroom, knowing already she's been sexually assaulted by boys.
Well,
Knowing already she's been, don't go around, answer my question. Knowing, because that's what they plead. Because you haven't given them a chance, the court didn't give them a chance to have discovery. This is on the pleadings, which all presumptions and inferences are for them, not you. Knowing she had been sexually assaulted by boys and tell her to go into the boys' bathroom, you think that a person with any common sense would think that's reasonable? Answer that question. Answer that question.
I do, Your Honor, and I think the question is—
you think that's common sense? Right?
Yes,
That's
based on
okay.
the
Tell me
law,
why.
the
Tell
law
me-
that was present in 2021 when these
There was
decisions
no
were
law,
being
there's no
made.
case law. Can you point to a case law that says that?
Grimm versus Gloucester says that if the student is identifying as the opposite gender, then that they're entitled to use the restroom of that choice. And so that the student said,
Their choice.
identify.
This is not even choice. You told her to go in there. She didn't
And
make a
there's
choice.
no-
Counsel, she did not. You got to go by the pleadings. You can't go by, you're telling us stuff that you're concluding. I'm talking about the pleadings. They told her, oh, you go into the boys' bathroom. This is not a case, you're trying to mix this with a case where transgender rights are saying, well, the school is saying, no, we're not going to let you use the bathroom, and you're trying to, this is not that case.
Well, to Judge
So don't try to make
Wilkerson's—
this case, I know what Judge Wilkerson said, I heard. I'm talking about I'm asking you questions now.
I understand, Your Honor. And I want to be clear, the allegations about what happened on the bus, there's no claim of sexual assault. There were claim of
They did
things
say it
being—
was sexual assault. They said they knew before she went in there that she was sexually assaulted.
If we look at the allegations as to what was alleged to have occurred on the bus, there were statements that were made
I'm
to
talking about
the
the
student.
pleadings.
And I'm looking at the complaint, Your Honor. The allegations about what was alleged to have occurred on the bus, which predates the time in which she was allegedly told to use the boys' restroom, do not indicate a sexual assault. There were profane epithets at her, threats, but she was not sexually assaulted. She was not physically touched. And in response to these allegations, the video was reviewed.
A sexual assault requires touching? What law school, assault requires touching? Excuse me? Did you say that? Did you say that assault requires touching?
The
That's what you
allegations,
said, didn't you? I don't know about that.
Ms.
I took-
McAllister stated that there was a sexual assault on the bus, and there were
you
threats
said
and sexual
because they were
harassment
threats-
made on the bus.
You said because they were verbal, they couldn't be assaults? That's what you said, didn't you?
That was not what I intended, Your Honor.
That's what you said, though, and that's not the law. Argue the law counsel and argue the facts and argue the pleadings.
There was no clearly established law at the time in August of 2021 that would have informed these school individuals that they would have been violating a constitutional right to familial privacy or the upbringing of one's child by failing to inform the parent that
It's not just, you keep going back, this is not about information. We're talking about a tender-aged child. We're not fighting over information now. We are fighting over, in terms of this case, whether or not a child is going to be protected from sexual assaults. And you send them into the boys' bathroom. Forget about the information. For example, what if she was, and this is a hypothetical, obviously. Child is pregnant. It says, I don't want my parent to know about it. But in school, you see that she has profound bleeding, all times of problem, and you do nothing about it, and you said, well, we didn't do anything because she said she didn't want her parents to know that she was pregnant. Do you think that would be the law? You could just say, yeah, I know she was hemorrhaging and told us things like that. There were all kinds of situations, but we couldn't tell that because that would be conforming to her parent that she's pregnant. You think that would be the law?
those aren't the facts of this
I
case,
did
Your
not,
Honor.
no,
You're-
wait a minute. I know they're not the facts because hypotheticals seldom are. They wouldn't be hypothetical.
Correct, Your Honor. And someone bleeding obviously implicates major health concerns.
Oh, and somebody being assaulted is not?
Miss
Someone
Blair,
being assaulted is not?
Miss
Matter of
Blair
fact,
was
more people die
informed.
from assaults and gunfire and all those kind of shooting, being beaten than they do for people dying from natural
Miss
causes.
Blair was informed that there was an incident on the bus, and she picked up her student from the
A
school.
sexual incident.
And there were no further incidents reported until we get to August the 24th, and the student informs the counselor that there had been issues with harassment in the bathrooms, and they reviewed video footage and met with the student. The issue is whether it was clearly established that this would violate constitutional rights, and the right here.
What about Title IX?
Title IX has to do with deliberate indifference and whether the response was clearly unreasonable. We have a report of an incident on the bus. It is investigated. The student is picked up from school. There's no allegations that there were further incidents
So
on the
under
bus.
Title IX, the Davis case, the standard is one of deliberate indifference.
Yes, Your Honor.
It's not a negligence standard or whatever.
Correct.
And the record is replete with efforts that the school board and Olson took positive steps to try to resolve the situation, talking to the victim, talking to the alleged, to those who allegedly harassed the victim. It wasn't the fact that there's simply no evidence here that the school board sat on its hands. And the Davis case makes clear that the standard for student-on-student harassment is a deliberate indifference standard, and it's a high bar to meet.
Yes, Your Honor. And each time the school officials were informed of an incident involving the student, they took action to address those incidents.
Well, let me ask you, on the Title IX, though, the school board has an internal policy that these things are supposed to be reported to the Title IX coordinator, and I don't think that you all dispute, and that is one of the things that is alleged here. I don't think you all dispute that the Title IX coordinator was not notified of the incidents that were going on here. So would that be deliberate indifference?
It is not, and the case law says, Your Honor, that failure to follow your own internal policies does not rise to the level of deliberate indifference. It's what you look at the response, and there was a response. There was investigation, there was an attempt to figure out what was happening and to address it, and the student ran away before the bathroom incidents could be fully addressed. She ran away the same day that they were notified and met about those incidents. So we would argue that there was no deliberate indifference and the response was not clearly unreasonable as a matter of law.
And how do we know that? What Judge Wilkinson just related to in terms of their attempts, is that from your pleadings?
That's from the complaint. The complaint here alleges that Ms. Olson reviewed the bus video, met with the student, interviewed students who were on the bus, and then had Ms. Blair pick up her child from school to avoid riding the bus. And then again, that there were investigations and review of video when the bathroom incidents came to light. So that's all in the complaint itself. So on its face, the complaint pleads that the school board took action such that it was not deliberately indifferent to the allegations.
And the action it took was to tell her to use the boys' bathroom.
No, Your Honor.
It wasn't? It wasn't?
When the school learned that there was an incident with using the bathroom, they directed her to use the nurse's restroom.
No. I'm talking before that. They told her to use the boys' bathroom.
That is the allegation in the complaint, is that after the incidents on the
And they were aware that
bus.
she had been sexually assaulted on the bus.
They were aware that there were incidents on the bus, Your Honor.
Sexually assaulted. Yes?
There were,
Yes?
there were statements made to her of a sexual nature, yes.
Yes, and there were sexual assaults, right?
I think, I understand the court's
Well, you know,
position on
in terms
sexual
of
assault.
Title IX, we have cases where people who are college students, we're talking about a 14-year-old, college students who are women, athletes, for example, in situations that are uncomfortable situations where, I remember cases where being alone in a room with a coach and all those things like that, there are all kinds of protection in Title IX. If you're talking about now, a 14-year-old child that you knew that had sexual assault history and mental problems, and we're saying as a matter of law at this point that that's not deliberate indifference. As a matter of, that's different. There's no discovery in this case. All of these things like that, the board's responsibility, not bringing in a coordinator, we don't know why. It seems like this case was in a bucket. This is a case dealing with a person who's identifying transgender, and then there's a whole set. But the law protects children. The Latin is in loco parentis, right? Therefore, you stand in the place of the parent, and that's a protecting parent, not someone who just leaves it to the situation for a 14-year-old and you know has a problem. This is cases, if this is the law, then once a person identifies as transgender, you could just do anything.
As Judge Wilkinson pointed out, the school board and school officials are in a very difficult situation. They're trying to walk this line. They're trying to protect their student who has identified a protected class, and they have to be careful about discriminating against that protected class. And so they do the best they can.
That they're doing the best they can. How do we know that? See, you're saying they're doing the best they can. That's what I don't understand. Where are you getting these facts from? That's based on facts.
It's based on the allegations in the complaint, Your Honor.
But the allegation in the complaint is that you knew this person before, that you knew they were sexually assaulted, and you got the police involved. Why did you call the police?
It's
You know
the
why?
allegations that the school
Why did you call
resource
the
officer,
police?
the allegations that the school resource officer, who's assigned to the school, met with the student
Okay,
and talked about
why
the.
was he involved? Or she?
Well, there were allegations of harassment in the restroom. They reviewed the video.
So it was
talked
okay to let him know, right? Him or her, I don't know.
It's a
right?
school official, they're dealing with the school issue, and then they let the mother know. They
This-
let her know. By the time that the student runs away, the mother knows everything the school knows, and yet seeks to blame the school division.
That's after the bathroom and everything, right?
But this complaint is based on, I have a right to know what's going on with my student at school. That is how the complaint was pled. So this is about information and whether the parent is entitled.
She also has a Title IX, that also has a Title IX.
She does.
Which I think, I mean, if I'm curious to know what your thoughts are as to this, how this case relates to the feminist,
Hurley,
case we
the
get.
Hurley
Yes,
case.
how is this case any different than that, where this court said that, I think they had the police escort the young ladies. I think they had these listening sessions, and then they sent out a generic email. How is this any different? Because I think what the court looked at there was that the action was taken pretty generally, and so her allegations is this is the same thing here, where there's nothing that's done affirmatively to protect the child.
So in Hurley, the allegations were that the actions taken didn't cease the harassment. Here we have a discrete incident on the bus. Actions were taken. There's no allegations that any further harassment occurred on the bus. No one knows anything for 2 weeks. We learn about the incidents in the bathroom. We meet with the student. We say, use the nurse's restroom. We start the investigation. And then the student leaves.
I
She
thought
runs
they
away.
I thought they went further in this case, and that Olson contacted Blair and
Yes.
said, pick up SB from school. And then she shared with Blair what had occurred, and said, you may want to pick up the child from school to avoid repetition, and that wasn't all they did. They didn't just sit back. They discussed the incident with SB, and this is drawn from the complaint.
From the complaint, Your Honor, yes.
We're not going outside the complaint. They have discussed the incident with SB the very next day. They reviewed the bus film. The two students who were on the bus and alleged to have harassed SB, they talked with them, and they contacted the mother and said, pick up. You may want to pick up your child. This is what's happening. And so if these were sort of just far-fetched allegations, that would be one thing. But these are drawn from allegations in the complaint, what the school district did. And this is, whatever you can say, well, this didn't work or whatever, we don't know whether it worked or whether it didn't work, but it was not deliberate indifference. How can it be deliberate indifference when you interview not only SB, but you contact Blair, you review the film, you talk to other the students who were on the bus? That is not deliberate indifference. Deliberate indifference means you turn your eyes and turn your head the other way. They didn't. They dealt with the issue. You may disagree with it. You may disagree with the way that they dealt with it, but they were not deliberately indifferent to this child.
I agree, Your Honor, and I see my time has expired, so I'll let my colleague, Mr. Butts, continue.
But if my friend and colleague has some further questions.
No, I have no further questions for you.
Thank you, Your Honors.
No questions.
Thank you.
Good morning. May it please the court. I'm Andy Butts, and with me today is Patrick Crowley, and we represent an individual in this case, Avery Villa. Mr. Villa was a psychology counselor. He was employed by a private agency, but he was under contract to the school board, and he was in a school, this school or another school, every day. So he was a borrowed servant. Now, I think under the civil rights laws, there's no need to establish employee relationships, but it's an important point because he was there just to provide psychological counseling as opposed to providing guidance counseling or make arrangements for the students. And in the time frame that took place here, all that happened was the following. First off, Ms. Olson, the guidance counselor, invited Mr. Villa to a meeting with SB. That was the August 12th meeting, and that was a meeting where the bus incident was disclosed. Next, at that meeting, SB did tell them that she wanted to be treated as transgender with regard to the male name and pronouns. She didn't want her parents to know, but she also reported that she had been harassed on the bus. So I understand fully and agree with where the court is coming from. There's something about this case that's not quite congruent, but I think there are more dimensions than I've heard talked about today. Now, Mr. Villa was not involved in the bathroom assignment, and there's no allegation in the complaint that he was. And by the way, this is a verified complaint. So at least for some purposes, the court, I think, has a right to consider that those allegations in the complaint that are favorable to a particular individual, like Mr. Villa, are admissions. Maybe a fine point in the law, but I think it's important because Mr. Villa is only there to provide counseling, and he met only a few times with the student with Miss Olson. He didn't, I think there's a report of 7 or 8 meetings with Miss Olson. He wasn't there most of the time, but he also was there the day that she reported the bathroom incident. So he's aware of it, but he didn't make the decision. And after that meeting, he had no further contact. It is true, he did not contact the parents, and to the extent that he had a decision about that, there's no allegation in the record one way or the other as to whether he should have and why. Now, the second thing that's really important is to understand the context. This occurred in the fall of 2021. And at that time, unfortunately, the school board had not taken any steps to announce or develop any regulations. But things were going forward in Virginia to make that happen. The Grimm decision, the last decision of this court, was issued in 2020, which the judge who wrote that opinion said a very hopeful, almost wishful closing in his argument. He said, I think the children of this country, the children of this state can get together and work better, and the parents shouldn't meddle too much. Well, that assumption assumes a lot of things, including what parents, what part of the state, what's the culture, and that sort of thing. Second, in 2020, the legislature passed a statute that was intended to advance pro-gender rights. And then finally, in 2021, in the spring, the Virginia Department of Education issued guidelines, proposed model guidelines that were sent to all the school boards around the state. What guidelines can do is they can inform the community about what the standards are. If those guidelines had been issued, I think the veto gave the counties a whole year to get theirs in place, we might have had a better situation. It might well have resulted in a situation where parents of a child like SB and parents of young boys might have known that this was something they were going to have to cope with
Thank you, Counsel.
non-violently.
Thank you, Counsel.
Okay, thank you.
You have some rebuttal time, Ms. McAllister.
Yes, Your Honor, thank you. Just a few things. As Judge Gregory has mentioned, of course, this is not merely the substantive due process claim for Mrs. Blair, but this is also the Title IX claim for Sage. And there are many, the biggest problem here is
Show
this is
me in your complaint where you allege deliberate indifference on the Title IX claim.
okay. The fact that they, the fact that in response to Sage's allegations, there are no facts saying that the school did anything regarding the boys who did this. There are no facts in the complaint. We don't know. We need discovery to find out whether, in fact, there were any actions taken against these boys, whether they were even questioned. We don't have that information yet because this is a 12B6. We don't have discovery.
Well, you know
but
that they interviewed the boys.
we don't have that in the pleadings, Your Honor.
Yeah, that's what I was thinking too. Where's that in the pleadings?
No, we don't have, we
It's
have
not
not
in-
pleaded that. We don't have, in fact, Judge Moon commented on that. Judge Moon said there are no allegations regarding any consequences or anything regarding the boys.
Hey, we're trying this case at the Court of Appeals.
And, yes, exactly, and we need, this court needs to send it back and let us develop these facts so that we can properly address Judge Wilkinson's concerns and Judge Gregory's concerns. And as far as the deliberate indifference, again, Sage was using the boys' restroom, and at the time, they knew that she had already been sexually harassed on the bus. They continued to let her use the boys' bathroom for 2 weeks. Finally, after 2 weeks, after other parents notified the school and said, hey, we hear from our kids
All
that
right,
there's a problem.
This is my concern, because what you've been over is that you're saying, well, they did this when they should have done this, and they did this when they should have done that. And the complaints here seems to be with the way that you disagree with the way that the school board responded. But there's no contention that the school board just let it lie around and did nothing. There are the complaints here are that they did A instead of B and B instead of C, and that's not deliberate indifference. And the Davis decision says that these claims should be few and far between.
Yes, Your Honor, my time has expired. May I respond?
Certainly.
Yes, the deliberate indifference also deals with the fact that, well, and we have the Hurley case. In the Hurley case, this court said, it's not enough to just do something, but you have to take action that prevents further incidences from occurring. There's no evidence they did that. They took some action.
What other instances of recurring is there? You just said you have to do something to prevent incidents from recurring. What other incidents were there that recur?
Well, we know that she was continuing to be assaulted in the restroom. We don't know, again, we haven't had discovery, so we don't know the extent of those. We don't know the extent of the knowledge. Maybe the school board, maybe the superintendent, maybe the counselor knew that, but we don't have that information because we haven't been able to obtain it through discovery. So we're asking this court to just send this back and let us have the discovery, let us find out the answers to these questions, and then there'll be a better ability.
The school board was drawing upon the allegations that were made in the complaint.
Well, no, Your Honor, the allegations of the complaint came after the school board did or didn't do anything. We don't know.
Yeah, your complaint says on J 79 in Title IX, officials' authorities failed to take measures in response to student sexual harassment. You talk about the counselor, and acted with deliberate indifference.
Yes.
That was severe, right, that's what you allege. And so I guess now we turn on his head that we don't take from those pleadings inferences drawn on those but instead,
Yes, Your Honor.
what we devise ourselves here at the court, appellate
Yes, Your Honor.
court.
Yes, Your
All
Honor.
right. That's all right.
Thank you, Your Honors.
We thank you. We'll come down and we'll greet counsel, and we'll move into our second case. prepared to proceed in Parker versus Martin.
Mr. Brandt?
Yes, sir.
Ms. Thompson?
May it please the court, I'm Lori Thompson here on behalf of Dan Martin, who is the principal creditor in Deborah Parker's Chapter 7 bankruptcy case. The bankruptcy code is intended to provide a fresh start to the honest but unfortunate debtor, but that is not Ms. Parker. The bankruptcy code is not intended to act as a shield to protect someone from fraudulent behavior, but that is unfortunately how Ms. Parker has used the bankruptcy process. She admitted that she filed bankruptcy for one and only reason, and that was to avoid paying Mr. Martin money that she freely admits she had the ability to repay him, that she had taken from her father's assets, that he was entitled to receive. She acknowledged that during all of the relevant time period, she had the ability to pay, but brazenly said, "I didn't want to." And as a result of that, she initiated a bankruptcy proceeding in Chapter 7 and has attempted to hide behind the skirts of the bankruptcy code. The bankruptcy court correctly held that this debt should be accepted from the discharge under 523A4, which was the embezzlement standard. Now, this court is looking to determine whether or not the bankruptcy court ruled correctly, but in my argument today, what I'd like to do is address the two bases on which the U.S. District Court reversed the bankruptcy court. The U.S. District Court did that on two grounds. First being that the bankruptcy court that heard the testimony of the witnesses committed clear error in finding that she acted with fraudulent intent. The second basis being...
At what moment or what point, I guess from the bankruptcy standpoint, are you alleging that Parker embezzled money? Because you got two different things going on here. You have the death of the father, and then you have the judgment. Are you saying that the embezzlement occurred after the judgment, or did the embezzlement occur after the death of the father?
So her wrongful conduct in taking money that did not belong to her, that she came into possession of, occurred when her father passed away in 2013. She came into possession of assets with full knowledge of the agreement and the will of her father, Morton, and his lifelong companion, Peggy, who was the mother of my client. Those actions continued. So at any point in the spectrum of time, Ms. Parker could have corrected her actions and we wouldn't be here today.
But doesn't she, I think her argument is that she was acting in good faith, that she spoke to the bank, and the banks told her that the money was owned because it was a joint account between her and her father.
Correct.
And that I think the banks pretty much told her she had the right to use the money. And so that's why I'm asking the question about when is it that we look at the embezzlement? Is that the money she spent after the father died, or is that the money that was spent after the judgment?
So I believe that the point in time that you are looking at whether or not this claim arose from embezzlement is when the claim arrives in the bankruptcy court, because you're assessing that claim that is filed in the court and whether or not it gives rise to an exception to discharge. So all of that conduct leading up to it is relevant and is evidence of her intent and whether or not that claim gave rise to it. Certainly, at the time that the court enters the state court judgment, one would think that she can no longer say, well, I believed I was entitled to this money. Her testimony is, well, I always thought I was entitled to the money.
But the judgment wasn't based on fraud, but it was based on, they found that it was owed to your client. That's different.
Well,
Isn't the race the thing? I'm back to Latin again. Isn't it the thing is just a judgment debt, isn't it? That's the claim. Your client's claim is a judgment debt, correct? Am I right or wrong?
you are accurate.
All right, so then the question becomes then whether that's dischargeable is what, because people discharge judgment debts all the time,
Correct.
right? So the question then becomes, how do we know? Because you have to hang all of your things on the finding for the bankruptcy in terms of it relates solely to embezzlement, not a fraudulent conveyance. So you don't get the full range of dischargeability. Yeah, yours is solely embezzlement. And going to Judge Benjamin's question, the question at what point in time is important, because if her father says, okay, listen, I'm turning this stuff over to you. You do this, joint accounts and all those things. You have to show that she received it for a purpose that was different than what she was told to use it for. And what is that? And based that's in the judgment. Well, how do we know that judgment? Because I've looked at the judgment from the state court. Didn't find it on fraud at all. It just said you owe the money. But yeah, people do it. Yep, I bought a house. I couldn't pay for it. I owe the money. You got a judgment against me. That doesn't mean it's not dischargeable. So where do you have?
Correct.
What do you have that judgment, that race was based on embezzlement?
So in assessing whether or not a claim is accepted from discharge, the law is that the bankruptcy court needs to look to the character of the claim. So Mr. Martin and Ms. Parker were not in a creditor relationship prior to her taking money that was directly to be given to him. Under the agreement and under the will, it was very clear. 2/3 of Mr. Morton Poindexter's assets were to go to Dan Martin.
His estate.
His estate, but also more than that, Your Honor, and that's an important distinction that the district court did not address when it looked at just what the will said. So it was more than just the estate. That was determined under the will, but under the agreement, there were two provisions that were critically important. One is that there was a restriction on any lifetime transfers of more than $1,500 on an annual basis. And it said you could not do that to the children because you were to preserve all of the assets. Because remember, Morton has now received all of Peggy's assets, which were Mr. Martin's mother. And so he has to preserve those because he's the surviving spouse.
So who breached that contract?
I'm sorry?
Who breached that contract?
So Morton breached that contract when he added her to the accounts. At the point that he added her to the accounts, he made transfers exceeding $1,500. And when Ms. Parker
But that's not
receives a
embezzlement.
copy of the agreement,
That's not
when she-
embezzlement. That's not embezzlement. For example, hypothetically, that could be co-conspirators. It's not embezzlement. Otherwise, if you agree to give me something that you weren't supposed to give me, I'm not embezzling. I may be a co-conspirator, but I'm not an embezzler.
and that's where the fraudulent intent comes in. So the elements of
Fraudulent
embezzlement
Do you-
are,
Do you think there's a difference between embezzlement and fraudulent intent, or do the two overlap?
so fraudulent intent is an element of the embezzlement claim. So
Yeah, it's
you
just an
have to
element.
show that you came into possession of property lawfully. So that's how she got it. She got it by the change of the name on the accounts. But that you then exercise control and dominion over that property, and you are not lawfully entitled to it. And she is not lawfully entitled to it under the agreement and under the will, which the state court judgment said those are enforceable documents, and she
But
is
the
not
bank
entitled to
told
those
her that
monies.
the bank told her that she was lawfully entitled to it. Just like if I have a joint account with my husband, I feel like I'm lawfully entitled to that, right?
Correct. That's why
But
she
the-
became in lawful possession of it, but she didn't get to keep it. That's the thing. When she came into possession of that, what the bank was saying, and again, she goes in, she talks to a bank teller, and a bank teller said, your name is on the account. When he passed away, you became the owner of it. So when she became the full owner of it at his passing in 2013, She knows that there is an agreement that she is not entitled to receive it, and she knows that there is a will that says exactly how his assets are to be administered. It's the combination of the agreement and the will that locked up all of their assets and provided that they would all be administered in accordance with an agreed plan. Because we have to remember, Peggy is deceased at this point. She trusted that Morton would follow through with the plan, and Deborah Parker is trying to get a windfall with full knowledge of what's going on. And the element of intent that the U.S. District Court reversed the bankruptcy court. Keep in mind, the bankruptcy court, we had a trial. We had evidence put on. He heard
So
Ms. Parker testify.
Parker knows about Morton's will, and he knows about the agreement to Peggy, and he knows about the executive's directions. And you're saying that Parker has actual knowledge that the money is not hers.
That's what the bankruptcy court found. Based on her testimony, it determined that she had full knowledge when she read those documents. And if you look at them, they're not difficult documents. What the U.S. District Court said is...
But you would agree that the bankruptcy court ignored, I think the bankruptcy court said there was nothing that said that she was entitled to those funds. That bankruptcy court completely ignored anything about the bank telling her that those funds belong to her. Because that's her good faith argument, is that the bank told me that these funds belong to me because this is a joint account, my father's died, and so now I am the sole survivor on the account. The problem I see with the bankruptcy court's order is the bankruptcy doesn't say, I'm sorry, Ms. Parker, that's not credible. There's no credibility finding, there's no finding of bad faith, there's no evidence, cross-examination by your client, and none of that is explored by the bankruptcy court. And so I think that's the issue that the district court had when the case came to the district court.
So the finding that her credibility was not, was ruled to be in question by the bankruptcy court, and that it didn't buy it when she said, well, I thought I was entitled to this money. When she testifies that she always thought she was entitled to this money. She would tell you today she thinks it doesn't matter that a state court judge ruled against her. She will say that, but the judge, I'm sorry.
Yeah, I guess the problem is you're talking about embezzlement and fraudulent intent. And so we've got to be able to see where this fraudulent intent, and in showing intent, he's got to either say what the bankruptcy court said was that, well, there's no evidence that she thought that the money belonged to her. Well, there is evidence, because it was what the district court said, because she went to the bank and the bank told her the money belonged to her. And so then at that point you would think the bankruptcy court would say, but we don't find that to be credible because she knew bam, 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 bam. But the bankruptcy court doesn't do that.
It did not state explicitly, that's absolutely correct. It did not state explicitly that she's not credible, but consider the evidence that the bankruptcy court heard of her behavior. We know that after, in 2014, she gets sued in state court. Okay, so she's been sued because she's not entitled to that money. What does Parker do? She goes on a spending spree. She does cruises, she buys a timeshare, she buys a diamond ring. We put on evidence of all of her expenses. Then we fast forward to 2019. In August, the state court says those agreements are enforceable. You are not entitled to that money. That's in August of 2019. In September, it issued the order that said so. What does Parker do? She clearly has the money to pay. She can do it at any point. Does she repay the money? No. She says, I didn't want to pay him. So what does she do? She stalls. We have the emails from her attorney that says that he noted an appeal with no intent to prosecute, just to stall. That was Exhibit 18. We have emails between her state court attorney and her bankruptcy attorney, Exhibit 17, stating the goal is to push everything out as long as possible so that Debbie can proceed with filing a Chapter 7. And then she takes all of the cash out of her bank account. She moves $245,000 to pay off tenants buy the entirety's property, and then she files a bankruptcy case with debts that only include Mr. Martin's debt. There are 2 very small debts, but really she had no debt. She ran up a credit card debt within 3 weeks before to the tune of about $4,800. She listed her father's burial expenses, which are not her debt, they belong to the estate, and she listed her HOA.
Everything you
This
said-
is all a fraudulent scheme.
Everything you said sounds in fraudulent conveyance, not embezzlement. These things are important. I mean, I did some bankruptcy litigation in my practice, and I know a little bit about it. But they're very important. It's not just because fraud is generally, yes, fraud is an element of a whole lot of crimes, but it doesn't make it embezzlement. It's just one of the elements. What you said may very well be evidence of animus. I don't want him to have a dime of it, so I'm going to spend my money, which I believe is mine, and I'm going to make sure it is mine. That could be just animus. I don't like him. I'm just hypothetically. I don't know. I've never met the people.
Admittedly, this is not the traditional definition of embezzlement that we tend to think of, but if you look at each component of it, we are met. She came into lawful possession of the money. She was not entitled to that money because it belonged to others, and she took it with knowledge that she wasn't entitled to it.
Oh, wait, it belonged to
times.
other people when she got it? No, he was living when she got it, wasn't she?
Yes, Your Honor,
Right? He was living, so they weren't entitled to it. Your client wasn't entitled. For example,
she received it upon his death.
Could he not have spent every dime of his money living while he was living?
Subject to the provisions of the agreement for his use and maintenance, the agreement specified how much of the money they could spend while he was living. But yes, what he could not do was convey more than $1,500 to any of his children. That was specifically prohibited. And she received all these assets at his death in 2013 with full knowledge of the agreement and the will at that time.
Yeah, but these instruments say that it was hers upon his death. He was not seized of it at his death. I mean, that's what's pay on death. POD means exactly what it means. The person who died is not seized of it at the point they die, so it's not a part of their estate.
So that's part of the property of another. The property of another is the equitable title to those assets. Who do they belong? Just like in the case of In re McNew, where the person works for the company, they are lawfully entitled to manage all the money, they're on the accounts, but they're not entitled to keep that money because it doesn't belong to them. It belongs to the company. So yes, she did have lawful possession, and that is one of the elements of embezzlement, is that you came into possession lawfully, but she didn't have true ownership entitlement to that because of the equitable claims of how it was owed.
The difference is this. She was in lawful possession. Your problem is, this is the arc where you get it, that it's, you use it for a reason that was not intended. He intended when he signed the documents for POD. See, that's the problem. When he signed that says POD, that was his intent. Embezzlement requires you to get it lawfully, that's the first element, and then to use it in a way that's contrary to the basis for which you received it. Nothing is contrary when you sign the bank documents and says POD. It says pay on death. He signed it. That's not that. So that's the arc you're missing. Then you skip over to the third one. Well, it really belonged to my client. Eventually, perhaps, but the problem with embezzlement is he signed it off, and POD means exactly what it says. And that's not contrary for you to keep the funds that you received at the death, legally, right? Am I wrong? Maybe I'm wrong. Tell me I'm wrong. Legally
My
now.
time is right.
Your time-
My time is up.
Well, go ahead. I think the chief might let me. It's up to-
go ahead.
all right, go ahead.
Okay. Yes, she lawfully came into possession of the money as a result of the POD, but she was not entitled under the law to keep that money. It had to be paid to Mr. Martin because it was given to her in violation of the agreement and in violation of the will, and the state court ruled that
So that's a
he
breach
was.
of contract. That's a breach of contract. That's not embezzlement. That's a breach of contract.
Thank you.
Thank you.
All right, let's hear from your side of it, Mr. Brown.
Your Honors, good morning. Robert Brand for the debtor, Ms. Parker. My wife texted me, "Don't make a fool of yourself," before I walked into the courtroom. hopefully I could be successful at doing that. It's my first time. I'm a little bit nervous. Here's what the case is about. Dad made a promise to his quote-unquote wife that he would abide by an agreement. The father fails to abide by the agreement and gives away most of his estate. The daughter, the debtor who files for bankruptcy, receives the estate. And the other party wants to punish the recipient, the debtor who filed for bankruptcy, for her father's willful breach of a contract that he entered into with the debtor's stepmom. That's big picture what we have here. Second big picture, which I argued in my pleading and regretfully did not cross appeal on, one of the reasons that the plaintiff were unable to prove embezzlement at trial, and I hope the point got across, is because they did not walk into the courtroom intending to argue embezzlement. It's pretty hard to prove a cause of action when you walk into the courtroom and you draft a pleading with no intent of proving that cause of action, and through serendipity, the bankruptcy judge hands you a cause of action at the bottom of the ninth inning as the case is wrapping up. So it was the bankruptcy judge who pointed it out to the plaintiff, hey, by the way, how about embezzlement? What do you think of that? And then the plaintiff scrambles and tries to make an argument. And again, the importance of that is because of the state of mind, because of it was clear that they were in there to argue conversion, and the pleading said conversion, 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 and out of that we're going to argue fraud, we're going to argue this and that as far as exceptions to discharge. They did not question the sincerity and the testimony, the truthfulness, the credibility of the debtor who filed for bankruptcy.
Well, let me ask you this. So I asked her this question: at what moment in this whole process is she asserting that there was embezzlement? Is that when the father dies, or is it after the judgment? I'm not sure. I think she's pretty much saying it's both. But tell me why, after your client has this judgment from the state court saying that you owe a certain amount of money, why is it not fraudulent intent when she goes and spends the money or it does whatever she does before she files a bankruptcy?
I would say the deed is done. So the critical time for the embezzlement to be proven was after the death of the father, in the weeks following the death of the father, because you have to show the state in embezzlement. It's about the state of mind.
But you would agree she disposed of some of the funds after the judgment from the state court.
The judgment being, I think, some 5 years later, if not more. The lawsuit was filed some 6 months after the death of the father, and the lawsuit languished in state court, it's right there in the transcript, for about a good 5 years before a ruling was finally rendered. So all kinds of events transpired during those 5 years. In fact, the bankruptcy judge says something to the effect of tracing. If you read Judge Kenny's opinion from the bankruptcy court, he says, I'm paraphrasing, we don't need to bother with tracing at this point. The focus being the debtor's state of mind when she received the funds a couple of weeks after the death. That to me is the critical timeline. And if I could just step back for a moment, because I'm constantly thinking of examples. So big picture, embezzlement, sometimes it's a slam dunk, right? The quintessential example, the bookkeeper, she's greedy, she hates her boss, I'm underpaid, she grabs $50,000, or she's doing it for years. There's no defense to that, okay? And it's a slam dunk, okay? We don't need the bookkeeper to make a confession. The state of mind was obvious, and there's no one in the room that's going to believe that the boss gave you an extra $50,000 and you misunderstood. But life is about the gray zone, and cases that end up in court almost always involve grays. So I'm thinking in my head of all the situations where you take an engaged couple and there's an engagement ring of $30,000, and 6 months later.
Let's suppose that somebody just phrased the case in this simple terms, that that Parker had knowledge of Morton's will, his agreement with Peggy, et cetera, et cetera. The money that she took for a series of very lavish expenses and personal expenses she knew was not hers, that accordingly she acted with fraudulent intent in taking money she knew belonged by virtue of the wills and the agreement. She knew it belonged to someone else. She took it for herself over and over and over again. And that kind of misconduct, why should the state court judgment then be dischargeable? Suppose someone framed it just that starkly.
In other words, the fact that you are lavishly spending the money that you received not that long ago goes to the presumption that you know the money doesn't really belong to you. So I would say that the fact that I'm lavishly spending does not equate to, I know in my heart of hearts that money doesn't belong to me. Which is what you need to prove in embezzlement. And any explanation
But
that
did the bankruptcy court's finding cover that? I know that this money does not belong to me.
I'm sorry, Your Honor, please repeat.
Did the bankruptcy court's fraudulent intent finding cover the point that you and I just discussed, which was that she knew the money did not belong to her?
No, Your Honor. The way I recall the opinion is the bankruptcy judge simply stated, you read the will, you speak English, you know what the will said, ergo embezzlement. That's it. In fact, made a point thereafter to state, if I recall correctly, I'm not even concerned with the whole business of how she spent the money. That's I'm not even taking that in.
What did the bankruptcy court's finding of fraudulent intent, what did it mean? Was it just an empty finding, or what were the implications of it?
With the utmost respect to Judge Kenny in the bankruptcy court, yes, it's literally one sentence. It's, you read the will, and I'm paraphrasing, that is the epitome of embezzlement, period. By implication, you read it, you should have known what it said, it clearly states what it states. By implication, you didn't like what it states, you pocketed the money, that's embezzlement. And respectfully, he oversimplified embezzlement. He turned it into a per se rule. He turned it to a strict liability statute.
How is it oversimplified? How would you have written? What would you have said that the bankruptcy court did not say?
That, again, respectfully, simple finding applies to conversion. The Corvette is not yours. I've proven that the Corvette belongs to me. Is it in your possession? Yes, it is. But let me explain. There is no but let me explain. This is conversion, the tort of conversion. Period. The end. I win. That's not embezzlement. Embezzlement, you have to go up 2 rungs on the ladder, and I've seen courts use the term felonious intent. So it's a whole different ballgame. Your state of mind, your intent greatly matters. By the way, plenty of case law says someone who makes no concealment of their actions, i.e. spending lavishly, is someone, the presumption is, who believes that what they're doing is correct. The bookkeeper who steals, the bartender who steals, hides their embezzlement, keeps it in the dark. The person who believes they're innocent and they did nothing wrong goes about their business and spends their money and says, hey, I've checked with the authorities. The authorities have assured me again and again that I have a right to keep the money.
Would there have been other statutory sections in Chapter 11, other than embezzlement, that would have applied to render the funds non-dischargeable? Let's say your view is that embezzlement doesn't work. Are there other causes of action under the code that could have been brought that weren't?
They were brought. The plaintiff argued fraud and defalcation and I believe, I'm sorry,
None of them prevailed.
right. Right. And none of them prevailed, and then the
Then what?
judge, I'm sorry.
I didn't hear your last words.
I was fumbling with the third cause of action that I can't recall at the moment, but
No,
yeah.
let's say you were representing those that wanted the judgment non-dischargeable. What do you say would have? I understand that your point with respect to embezzlement, but what cause of action do you think would have been more successful?
Be careful, malpractice.
I'll be honest, I've had tunnel vision the last 72 hours over embezzlement that
No.
my,
I'm just interested because in the general proposition that someone can behave this way and have it dischargeable, but
okay, I'll answer it this way.
no, I know we're all into embezzlement, but just
It doesn't seem right that this should be the legal result. I fall back to Congress, and unfortunately, yes, there are instances where it doesn't seem right, and the court doesn't feel right about issuing the decision that it should based on the law, because, to put it very simply, it doesn't seem fair. But respectfully, that's not the rules of the road. And quite frankly, that's precisely what happened in this case. If you read the transcript, it is clear that the bankruptcy judge knew at the conclusion of the trial that none of those causes of action would work. So he inserted himself and said, want to try this one, embezzlement? I just want to make sure I'm saying these two critical phrases. An erroneous belief of entitlement, in plain English, if you have reasonable justification to believe that your actions make sense, it's not embezzlement. I am the remaining heir of my father. I'm spending more time with him in the last few years. He never informs me, this would be a game changer, listen, honey, I love you, but I'm giving most of my inheritance to your stepbrother, right? None of that evidence, none of that takes place. Father passes away. the daughter, like any normal daughter, expects that the bulk of the inheritance is going to go to her, and then she receives a shock, and she testifies that she's confused by what she read.
So you're saying that the bankruptcy court alighted upon embezzlement because he knew that nothing else would do?
Yes. Yes, yes, the judge wanted to do the right thing, so he spoon-fed the plaintiff a cause of action of embezzlement, yes.
Let me ask you about the district courts. Beyond the embezzlement, the district court says that, basically says that the contract is invalid, makes these other rulings, that the amount is not correct. Would that be error on the part, under res judicata, would that be error for the district court's findings there regarding the contract, things that were already decided on the state court, when the judgment came about?
I think that the district court judge, Judge Ellis, who I believe is now retired, did a surgical strike and a surgical analysis, line by line, of the opinion of the bankruptcy court. I think he's a lot more intelligent than I am, and he explained in great detail what constitutes property of another, and explains the presumption that even the bankruptcy court made that everything was the property of another. And Judge Ellis says, well, let's look at this more carefully. It's not quite that simple. And as I'm getting slightly confused in my mind, it's something else occurs to me. Even now, you could see various counsel arguing over what precisely the document meant, didn't mean.
I know, but I guess at the point where it gets to the district court, there's already a state court judgment.
Yes,
And
sir.
so the district court goes in and says, oh, this post-marital agreement is not a valid contract. And then the district court says that that there's a question about the, I want to say maybe the amount, or about the judgment. Wouldn't rules of res judicata bar the district court from doing that?
Yes, I think the point that Judge Ellis made is that the cause of action in the state court was simply breach of contract and unjust enrichment. That's here. But then over here in bankruptcy court, where you're arguing embezzlement, the angle is different, and you have to prove a different cause of action, embezzlement. The assumption is, almost always, it goes without saying, that you took all of my property. You took my car, you took my money, you took my house, and you have no justification for doing so. And he simply said, slow down, guys. You're assuming that the 5 different sources of inheritance that the debtor received, all of which was property of another, the plaintiff, when in fact it's not quite that simple. And he goes on to explain item by item what is property of another and what.
I know, but it seems as if maybe the district court went a little too far in, because there's already a judgment from the state court, right?
Yes, a judgment for breach of contract.
You're under
right.
full faith and credit,
Right.
and all of that. So it seems like the district court may have gone a little far in determining that the contract wasn't valid, questions regarding the judgment. But let me ask you this, so let's assume if we say that there was some error by the district court, I'm assuming that you're gonna say that the district court did not err, that there's no issue with those, with that error, because there's no fraudulent intent.
Yes, please. What you just said,
And
yes.
And the error would be harmless to that extent.
Yes.
Right.
Put it differently, it's an academic exercise. If there was no fraudulent intent, whether it's 100,000, 150, 200, there was no fraudulent intent, therefore, you can't find embezzlement. And I think my time is just about up. Thank you for listening. Thank you.
Thompson?
The elements of embezzlement, I'd like to circle back to those because, and with due respect to counsel, we did argue embezzlement. It was presented to the bankruptcy court at the hearing because embezzlement is the flip side of larceny. So in larceny, you come into possession of property.
What they're arguing is that before the bankruptcy court, that embezzlement was sort of a Hail Mary. And that he sort of looked in the cupboard and nothing else worked and said, hey, what about this? Let's try embezzlement, because none of the others fit. What do you say about that?
So,
Because it's not, I mean, it's not classic embezzlement, which is
correct.
Which is an inside job that somebody tries to hide. And there's a great deal of secrecy that surrounds embezzlement. You don't want anybody else to know, and you're taking money that is not yours from inside. And this isn't classic embezzlement.
Correct.
All right, so what do we do with that? Because is it just sort of a Hail Mary because nothing else would work to render the debt non-dischargeable?
I pled in the alternative and I argued in the alternative. Under 523A2, 4, and 6, that's what we do in every case where there is an issue about whether or not a debt should be accepted from discharge, where there is fraud, where there is a claim that arose as a result of someone taking something that didn't belong to them.
Excuse me, that gets to my point, and that is that there would seemingly be in the bankruptcy code all kinds of provisions that would have posed obstacles to the discharge of the debt, and that there were just a number of theories that could have been pled and could have been provided to render the debt non-dischargeable, and I don't understand why none of those why you availed yourself of none of those and went after and hung your hat on embezzlement, which, you know, strikes me we're trying to push a round peg in a square hole.
Each of the elements of an embezzlement claim is shown on the facts of this case.
Let me ask you this, but you didn't plead embezzlement.
We pled the statutory that it was accepted from discharge under 523A4, which provides that it is accepted from discharge for a debt for fraud or defalcation where acting in a fiduciary capacity, embezzlement, or larceny. That was what we pled under.
But if you look at the transcript, you all don't argue embezzlement until your closing argument after the bankruptcy court brings up embezzlement. And you do discuss it in your closing argument, because then I think they come back and start saying, oh, we didn't know embezzlement was a part of the issue here. But you do discuss it in a closing argument, but that's after the bankruptcy court, sua sponte, says embezzlement.
Well, as the testimony came in, that was what the facts gelled around as fitting to a T.
But but even on cross-examination, there's no question regarding bad faith. There's no question regarding fraudulent intent. It's really, I mean, it's more to the conversion and the breach of contract. It's nothing about anything.
I would respectfully disagree. I believe that the entirety of the testimony was to show the intent of her. She admitted brazenly that she did not want to pay.
Fraudulent intent and embezzlement. You got to show not intent, just intent to convert the money. You got to show fraudulent intent. And so I think but there's no cross-examination. There's no discussion about this fraudulent intent that leads to embezzlement until the bankruptcy court says sua sponte, something about embezzlement, and then you all discuss it in closing argument.
No, it was always intended to go into closing argument, but as far as cross-examination, I mean, short of saying you didn't really believe it when the bank teller told you that, I'm not sure how you cross-examine that. She says, I thought that I was entitled to the money. The bank teller told me that it was mine, but we got her to admit she read the agreement, she read the will, she presented no argument that she didn't understand what those documents were, and we were able to show that she thereafter engaged in, I'm sorry, Your Honor, I just noticed my time is up. May I answer?
The things that you're saying, you have a strong equitable case because of the degree of her awareness. It wasn't her, but it just, what's difficult about the case is that I'm not sure that it was pled correctly, or that it was argued correctly. It seems to me there's so many different provisions of the bankruptcy code that would have allowed you to take advantage of a very, very strong equitable argument to render the debt non-dischargeable. And I just don't understand how it all came to rest on this point of embezzlement.
Well, Your Honor, we pled and argued under A2, A4, and A6 that all were applicable in this case. That's what our original pleading was. That was what our argument was. Thank you, Your Honor.
All right, we thank you. We will come down and shake hands, and then we'll move into our final case. So,
good morning, Your Honors, and may it please the Court. Jenny Toma appearing on behalf of Richard Allen Smith, Jr. In his second appeal of the denial of his compassionate release motion, which is now in its 5th year of litigation. Richard Smith was gainfully employed as a coal miner for 18 years until work-related health problems forced him out of it. He unfortunately and regretfully developed a bad addiction to crack cocaine, which led to the events in this case. In 2002, Mr. Smith was sentenced to 54 mandatory years in federal prison, half of which was the 25-year stacked 924C sentence on count 46. At his original sentencing, then Judge Stamp noted that his sentence was, quote, severe, which of course it was, but he had no discretion in the matter. This was 3 years before Booker was decided and the guidelines were mandatory. And of course, the 25-year count 46 sentence was required by statute. This was also before Dean was decided too, so his hands truly were tied. However, whenever Judge Stamp had the opportunity, he reduced Mr. Smith's sentence at each point, and he went as low as he could each time. For the guideline amendments in 2008, and again under Section 404 of the First Step Act in 2019, down to 504 months, again, a large bulk of which is still that 25 years on count 46. In the last 25 years, he was taken into custody in 2000, and so in the last quarter century that Mr. Smith has been in federal prison, much has changed for him in that time, legally and personally. In just a few weeks, on June 1st of this year, Mr. Smith will be 71 years old. He has black lung disease from his years as a coal miner, and there is no cure for that.
You make a point of the stacking of mandatory minimums, and but the stacking of mandatory minimums, I think it's now forbidden, but it hasn't been ruled retroactive.
That's right.
And if the stacking of the mandatory minimums has not been ruled retroactive, to what degree are we really entitled to consider that under the 3553A factors?
Well, this court's precedent makes pretty clear, starting, I think, with Mangarella and also with Malone, that an extraordinary and compelling circumstance has to be considered as part of the 3553A analysis. It also has to be considered as an extraordinary and compelling reason at step one as well. So at both steps of the inquiry, it does have to be considered when it's raised, which of course here it was. It was a central thesis in mitigation. It is required, Congress also provided in 3582C1A that the district court has to consider an extraordinary and compelling reason that the Sentencing Commission provides for. And now on remand, after the first remand in this appeal, we supplemented to the district court explaining that the Sentencing Commission had...
So are you saying that retroactivity is no bar
It is not a bar, Your Honor.
to the consideration of something as a 3553A factor?
I think that's correct. I think, and also the Supreme Court made very clear in Conception that when it's raised, something like this has to be considered. So it is not a bar. Of course, it's not also a given that there will be a grant, but it must be considered at both steps of the analysis. Now, just to briefly recap his medical conditions, the damage from black lung disease is irreversible, and part of his right lung has had to have been removed. It shortens his life expectancy by over 12 years. Again, he will be in just a few weeks 71 years old. He also suffers from COPD, emphysema, prediabetes, a heart arrhythmia, and a cyst on his liver. Unsurprisingly, he is quite disabled at this point.
The question I have is if we were considering this as a matter of the first instance, if we were district judges, I think there would be a good case to be made for compassionate release. But here we are up on an appeal, and we're here under an abuse of discretion standard. And we've made the point many times, the fact that we might have ruled differently as district judges doesn't allow us to reverse on the idea that, on the theory that the district judge abused his discretion. There's a difference between what we would have done as district judges and what we're allowed to do as appellate judges under an abuse of discretion standard. And so I'm wondering how you get around that standard of review in this case.
In this case, the district court abused its discretion in several ways. So not just the failure to consider the unwarranted sentencing disparities in his count 40 sentences, but there was also two factual errors. It attempted to, surprisingly, reweigh the amount of relevant conduct that was properly found by Judge Stamp at Mr. Smith's original sentencing. That was 573 grams. And the district court undertook what I can only assume is maybe understanding that the basis for his decision otherwise might not be enough. He apparently sought to increase the amount that he thought should be attributed to Mr. Smith. And that's in contravention of this court's precedent. Most recently in Moody, this court explained that when the sentencing judge, the original sentencing judge, makes an express quantity finding, the court reviewing for compassionate release, his hands are tied. He can't then go back and say, well, I really think it should have been more. And that's critically important in this case because the amount of relevant conduct, Judge Stamp took a 15-minute recess at his sentencing and he reviewed the transcripts with the probation officer. And those amounts were based on witness testimony, and he was the only judge involved in these proceedings who actually saw those witnesses testify, and so he made presumably a credibility assessment of that testimony, and he came back after 15 minutes of consideration and said, the correct amount is 573 grams. Now, in this order, the district court said, well, 677, which is what was in the PSR, but also then undertook for a long paragraph to say it should have been a lot more than that. And it never quite get around to saying how much more it thought, but apparently it thought it was enough to justify the extra 18 years in part, which is not permissible. There are some exceptions to consider and reconsider an amount on compassionate release or First Step Back proceedings, but none of those apply here.
I understand that Judge Stamp may have been more sympathetic to your case than Judge Klee was, but we're reviewing not what Judge Stamp might have done had he still been on the bench. We're reviewing what Judge Klee did. And one thing he does is he makes a big deal of the fact that the original offense was a serious one, that there were large quantities of drugs involved, and the guns were pointed at law enforcement, even though they weren't actually fired. And is it an abuse of discretion, given the gravity of the initial offense here?
So I'm not here to say that any of us should be aspiring to this conduct. Certainly it was serious, but what it is not serious enough is to sustain. Basically what he's saying is that if Mr. Smith came before me today, I would vary upward 18 years for this. The extra 2 years for brandishing is already accounted for in the statute. That's why its sentence is 18 years too long and not 20. Moreover, he made two factual errors. He failed to recognize factors constraining it by trying to reweigh the relevant conduct. And I also would point out that he talks about the importance of deterrence, and that's irrational because maintaining a sentence on the count 46 that is 18 years too long today in no way can deter a would-be armed criminal because those penalties aren't on the table for them today. It has no deterrence value for would-be criminals today.
Is this individual still ambulatory?
He can walk, but slowly. He has a lot of trouble breathing. He can walk.
You said he's missing part of a lung?
He is. He is slow in his progress.
Is the nature of, does he have emphysema, or I think you said
he does. COPD and emphysema as well.
What are the extent of his breathing difficulties?
They are significant, Your Honor. He can walk, but he gets very exerted. He, at one point, explained that he had to have other inmates accompany him sometimes when he walks from places on the compound. He has, as you can imagine, it's a labor for him to move around. And I would also...
the disciplinary record, by and large, is pretty good.
It's among the best I've seen.
There were two infractions noted for insolence. Did they involve violent conduct of any sort?
They did not, Your Honor. It was a name-calling incident that occurred between other inmates, not Mr. Smith, and he was asked to provide information to the CO, and he declined out of fear that it might involve some retaliation to himself, and he might become the subject of violence. He simply declined to get involved in that, rightfully so for someone in his condition, I would say. But I would also like to just make the point that the failure to consider the 924C disparities, there are 3 different kinds of disparities that represents. It's not, that reason, first of all, is not individualized to Mr. Smith at all. And this court and McCoy made very clear that the review must be individualized to the person before the court. That's got nothing to do with him. That's basically a blanket assessment saying, any defendant who comes before me requesting an unstacking or reduction of his 924C sentence, I don't believe in it. I'm not going to do it, even though the Sentencing Commission has made that expressly a ground to consider. And I also just want to point out that the three different kinds of unwarranted sentencing disparities that reflects include between co-defendants in this case. So he had a co-defendant, Roland Whitley, who also very briefly held a gun on the undercover officer who was posing as a drug dealer, or a drug buyer trying to buy drugs.
When you were talking here in your brief about the fact that some of the other co-conspirators have already been released.
All of them have already been
Okay, all of them
released.
have been released. But I think it's 3553A5 or whatever it is, where you ask whether the sentence is out of line with something. Haven't we taken the view that that is not when we talk about something that's out of line, we're not talking about out of line with respect to another co-conspirator, but we're talking about out of line nationally with these kinds of sentences that are being given.
Yeah, I just want to add that there are the three kinds of sentencing disparities are not just between the co-defendant, but also from the many defendants whose cases we've cited in our briefs who did far worse, whose cases did involve violent conduct, and
But
they
is
have
it
been
really a
granted.
3553A factor that other co-conspirators received a lesser sentence?
It is at minimum as part of the extraordinary and compelling circumstances inquiry because it is an unwarranted sentencing disparity, and that's in it's 1B 1.13.
But is the disparity within the particular case, or is the disparity one that's nationwide?
It's all of the above, Your Honor. And that is, as an extraordinary and compelling circumstance under the policy statement under 3582C1A, it has to be considered both at step one and as part of the 3553A analysis under this court's existing precedent. But I just also want to reemphasize that this case is unlike any of the others that the government cited in its briefs because the undercover officer who briefly had two of these gentlemen point a gun at him, he attested in writing, he put it in writing, and it's part of the record that he was unharmed physically or emotionally from this incident. This is not a case unlike some of the others cited by my colleague where there's trauma to the individuals, people won't return to work, there's hundreds of thousands of dollars of economic damages, there's harm to the victim, people were killed, maimed, seriously injured. None of that is here. None of that is here. And because of the district court's...
So what is the limiting principle here if normally a reversal for abuse of discretion has a much more far-reaching effect than an affirmance? And so what is the limiting principle here that is going to prevent this case from being thrown up to us in many future cases? What narrowing factors can you cite that will prevent me, so I won't be coming back to court and said, wait a minute, you did this past year, so and 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 so deserve to be released, and having this brought up to all kinds of district courts across the circuit, because as I say, a reversal for abuse of discretion has much more far-reaching effects than an affirmance. And so what's the limiting principle here in your view?
Your Honor, I see my time has expired, but
No, please answer that.
I think that this court doesn't really have to go much farther or even any farther than it has in the past. I think this court's existing precedent makes clear that when you make factual errors, as the district court here made two of them, when you try to reweigh relevant conduct, when you abuse your discretion in all the ways that we've explained, those are abuses of discretion, and I don't think you have to go any farther than this court's existing precedent to so hold. I think that the factual errors and the other abuses of discretion are enough, and they wouldn't really be a step farther than we have gone in the past. I'm happy to answer any other questions if the court has. Otherwise, reserve the
Roger.
remainder of my time. Well, actually, there's no extra time.
Do you have
Yeah.
some questions?
Does she have extra time?
I do not. Just my 5 minutes on rebuttal. No extra, though.
Yes, well, you have some
Rebuttal time, okay.
rebuttal time here. You
Yes.
certainly do.
Yes, thank you.
Mr. Warner?
Good morning. I'm Stephen Warner, Assistant U.S. Attorney in the Northern District of West Virginia, stationed at Elkins. May it please the court. Your Honors, in the District Court's first order, the 2022 order denying Smith's motion for compassionate release, the District Court said that even if it considered anti-stacking in its 3553A analysis, the sentencing factors still weigh against a sentencing reduction because a reduction would be inconsistent. It wouldn't reflect the seriousness of the offense, promote respect for the law, deter criminal conduct, or protect the public. In so finding, the district court leaned on the instant conduct and on the defendant's criminal history.
But he didn't consider the rehabilitative issues. You would agree, right?
Well, he said that he considered all of the defendants, the district court said that it considered all of the defendants' arguments and did comment on it was impressed with the rehabilitative efforts. So it did consider, and it said that it considered those efforts, yes. But nonetheless found that the 3553A factors weighed against them in denying the motion for compassionate release. It put heavy weight, all of its weight really, into the offense conduct and into the defendant's criminal history. Now, this court remanded because there were bad facts in that analysis in the first order, in the 2022. The district court wrote that it was over 500 kilograms of crack cocaine. It wasn't. It was really over 500 grams. And it wrote that the defendant's prior conviction was a federal felony when it actually was a state felony. So this court remanded and asked, directed the district court to correct those facts. And then,
And he still got it wrong, right?
No,
On the
no, I would.
facts, on the drug weight?
Well, yes and no, but yes, but not as much. You're definitely right. The district court took a 15-minute recess, and you can tell, and I knew you could tell that he was trying to get as low as he could on the relevant conduct to see whether it would go into the next guideline level. And the district court, I think Judge Stamp said he could only get it down to 570 some grams, which was about 100 grams less than the pre-sentence report had. And then the district court, in the order that brings us today, found what the pre-sentence report, 677 grams, when the district court the trial court had said 500 and some grams.
Well, let's put it this way. He has spent 25 years in prison. That's a big chunk of a man's lifetime. And the government has conceded here that he's established an extraordinary and compelling circumstances. So he's established the first prong for compassionate release. And he seems to be in rather bad shape medically. Do you take issue with opposing counsel's description of his medical conditions?
No, I agree with the medical conditions.
But that's a person who's in pretty bad shape. So when we talk about recidivism, there's no risk of recidivism here. That's one of the 3553A factors, is it not?
Definitely is.
Maybe I'm wrong, but this record does not suggest a recidivist to me. And then in addition, you have to look at deterrence. And it would seem to be a significant deterrent to anyone who's considering Mr. Smith's case that he only received after compassionate release, if he does, after 25 years in prison. The 25 years that he has spent in prison would appear to be a pretty significant deterrence, would it not?
I would agree with that, Judge, yes.
You would think twice if you looked at Mr. Smith's case. That someone has spent 25 years, that would be a deterrent. And you would think twice looking at his age, that the dangers of recurrence or recidivism had to be very low, particularly in conjunction with the rehabilitative history that Judge Benjamin has mentioned. What I'm saying to you is that this is not your strongest case to hang your hat on. Do you understand what I'm saying?
Absolutely, yes, Your Honor, I do. I respectfully, and I respect that different judges would disagree. Maybe many judges would disagree with the district court here. But all that is required for not to be an abuse of discretion is that the district court knew of the defendant's arguments, considered them, and had a reasoned or rational basis for choosing to deny the motion. And if you look
what are we supposed to do with the fact that this individual has lost part of his lung? That he's has been diagnosed with black lung disease, that he has a heart condition, that he has all sorts of pulmonary conditions. I mean, I don't understand what is to be gained from a societal point of view, or what is to be gained from a societal point of view, and there's in keeping this gentleman in prison after all this time, when the co-defendants have been released, when we know that if he had been sentenced today, it would have been substantially less. You have to exercise some judgment on this, and this is not a strong case for you.
Judge, I know that and I respect that, and I can clearly see that different judges would decide differently, but I keep going back and would continue to argue that abuse of discretion standard, this district judge didn't want to reduce the sentence. And if you follow that abuse of discretion standard, did the district judge, was he aware of the arguments? Did he consider them? Yes, he did. And did he have a rational basis for denying them? I would argue that he did. In his second, 20 more recent order that brings us here today, he was very concerned with the brandishing of firearms, that this man's crime involved 8 firearms, one had an obliterated serial number.
Those are all fair points, and I respect you for them, because they're certainly all valid points and all legitimate points. But this seems to me a sort of an extraordinary situation where you have somebody who's infirm and aged and has spent 25 years in jail, and would, by general admission, his co-defendants have long been set free. He would have been sentenced far more leniently had he been sentenced today than at the time. The fact that he's in prison now is he's sort of a victim of timing in the kind of way, but it just seems to me that this isn't if there is a case for compassionate release, this would seem to be it.
Well, I would respectfully agree that some judges would agree with that statement. Some district judges might have granted compassionate release. This one did not, and we argued against it. I know that, Your Honor. But we thought it was important the district judge saw both sides and make a ruling after hearing both arguments. But I just go back to and argue that abuse of discretion when this judge didn't want to grant release. He was aware of the arguments. He knew what they were. He looked at the instant offense conduct, and he did not want to grant relief. And I would just urge and argue that that was not abusive of him to not reduce this sentence.
I respect that, and those arguments that customarily have great appeal to me, but I have to look at the facts here. The man is missing part of his lung. He's 70 years old. He's no danger to society. Whatever years of life he has left, why not give him a chance? Thank you, sir.
Yeah, thank you, Judge.
Ms. Thelma.
Thank you, Your Honor. I do want to take a couple points of disagreement with my friend here. First of all, I don't think the district court was considering the disparities in his 924C sentence. It's JA 366, where it says, even if the court were to consider it, and I think the only real way to interpret that is that he was not. I also think that the district court's 3553A analysis at JA 363, 366, if you read that, you see basically several pages of just adding details about Mr. Smith's offense conduct and his 1992 West Virginia conviction for selling $60 worth of marijuana and a misdemeanor domestic violence conviction, and otherwise just talks for pages about his conduct in this case, which again was serious, but not an extra 18 years serious. And so you would see in that only one thing mentioned is just basically making it dispositive, his conduct in this case and his criminal history. You see at the end of that a half sentence, just one passing mention of his 25 years of positive rehabilitative conduct in the Bureau of Prisons. And this court has vacated and remanded for that sort of situation before in Gutierrez, citing Martin, which is also in our briefs. So that passing comment, you see the district court.
I don't know what would be gained here by a remand.
I tend to agree with Your Honor.
There's no prohibition on us granting compassionate release here.
There is not, and there is also a precedent for that as well. And we certainly would welcome that result from Your Honors.
Is there anything more?
I think that is the substance of it, Your Honors. I mean, of course, the relief we've requested is at minimum a vacate and remand to a different judge, but we also, in the alternative, would welcome the court's just reversal with instructions to grant. And again, happy to answer any other questions the court may have. Otherwise, we'll rest.
Judge,
Thank you, Your Honors.
we thank you both, and we'll adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.